Okay, at this point in the class, I want to go over some important theories and concepts that will, once you understand them, will make it much easier for you to understand legal studies and how it relates to the criminal justice system. So these three concepts are power, sovereignty, and legality. And I'm going to talk at the end a little bit about theory and in a way that helps you think about how to apply a theoretical framework in this class and in the future. So we start with sovereignty, and in the reading, you were given three narratives, three stories of cases of either groups of people or individuals who challenge a technical definition of sovereignty as we use it today. So what you should have learned from that is that with the reality of global migration, of people moving from one nationality to another, simply having a nationality in one place does not guarantee you rights under a sovereignty framework in a different nation. And that's a contradiction, right? The idea is if you're born in a nation, you should be given rights, and then those rights should attach to you regardless of where you go. But migration in the last 70 years has proven not true. That's not how human beings treat each other, even though the law says you're supposed to treat each other equally. So the first example I give is Keshwar, who's an undocumented immigrant in New York City. And he sees himself on the one hand beyond the law because it doesn't really apply to him because he's undocumented. He really doesn't get any benefit from it. But at the same time, he understands that he's subject to it. In other words, the criminal law could punish him. He could be deported under immigration law. So he's kind of stuck in this paradox of, on the one hand, being outside or beyond the law, and then on the other hand, he's under it or subject to it. In a similar way, Guatemala have been routinely targeted, and specifically so in the 1980s under the crime of genocide. And they've been continued to be routinely excluded from the political process, which then contributes to the discrimination, and they're also ongoing victims of violence. And so this one really shows you that this is a group of people that are from that area, so they have connection to the soil, which is another concept of sovereignty that people like to bring up, and yet they're excluded from being sovereign. They don't have autonomy, they don't have rights, even though, again, they're the original occupiers of that particular land. And so now you see a nationality that's actually excluding a group of indigenous folks. So you see that contradiction again. And then finally, I looked at the Rohingya because they were given privileged status, they were given privileged rights under British colonial law, but now under the new national law, under the nation state, in other words, the law of the quote-unquote people, they are excluded, and they are targeted, and they are victims of violence. And when all three of these groups leave the areas, whether it's Keshwar leaving Guyana, whether it's the Maya leaving Guatemala, or the Rohingya leaving Myanmar, they don't have any rights. And so they don't have rights in their quote-unquote home countries, and then they don't have any rights globally. And again, the law, the international human rights law, says they're supposed to have rights. But you require a state, you require a group of human beings who are actually going to enforce or apply those rights, and that's not existing right now. So your position within the society or the social structure, plus an education about rights, influences beliefs about what rights are to you and how they apply, and also what you think about social control. And so the most powerful don't believe that the same laws ought to apply to everyone, whereas people who have less power tend to believe that the law should apply equally to everyone. Common sense, what each group gets out of it, right? The powerless would like everyone to be equal so that they're more powerful. The powerful don't want everyone to be equal so that they retain their power. And if you look over at this graphic over here to the right, then what you learn from this, or what I learned from this I'm sharing with you, is that the concept of sovereignty is based on lived experience, based on those constituted identities. So the social structure creates your identity. Are you a citizen? Are you a subject? Are you a refugee, an immigrant? Are you stateless, undocumented? Are you part of the surplus population? Are you a prisoner? Right? That constructs your identity, and then based on that lived experience under that identity will determine what your view or what your belief of sovereignty is. And so sovereignty is not one thing, it's multiple things. Now this has a practical consequence because the majority of citizens within the United States who are in fact citizens, they see compliance as a choice, right? Because they're the majority, that they're participating in the legal system by choice. Whereas they then have the ability to essentially pick on the minority, stateless, undocumented, and the surplus population, because they don't have to apply the law equally, right? And so their ideas about law being a choice are what then allow them to discriminate against other people. If you think about it more from people who think about individual rights versus property rights, they tend to see compliance as moral. You don't have to follow the law, but you should. It's a good idea, it's good for you, it's part of the social compact. We've all agreed to do it. And so when they look at people like refugees and immigrants, they say, well, we've agreed to take care of people, and so therefore refugees and immigrants should get equal rights. Now, that's only if you get to qualify as a refugee or immigrant, and say they set up a system usually based on property rights. Do you have access to property? Did you have property records in the country you came from, right? There's all these ideologies that come from this viewpoint, and so that's what directs the compliance, right? You should comply if you share the same moral ideas I do about property. And there's lots of, maybe hopefully in one of your classes you've learned about John Locke and some of Rousseau, these other philosophers who really put together this idea of compliance based in property rights. And again, that's based on a compact. You don't have to follow the law, but it's a good idea because we've all agreed on these kind of shared norms. Now again, you see that the power group is the one who gets to decide who the refugees and immigrants are, and then who the others are who aren't included in that group. I wanted to compare this because the original concept of sovereignty, as we know it or we talk about it, is actually from the medieval period, and that's when there's kings and kingdoms. Now what's interesting about that is that law is a command, right? So when a king gives a command, all the subjects have to follow it. On the other hand, all of the subjects are the people who are in the jurisdiction of the kingdom. So it doesn't matter if you're a refugee, an immigrant, stateless, undocumented, surplus, it doesn't matter who you are. If you're in the kingdom, you must follow the king's laws. And so that's where this idea of law being a command really goes with the sovereignty idea of a kingdom. So law as a command doesn't really apply in the social compact or the council idea of sovereignty. And so this is where we kind of get into trouble when we start to think that law is one thing. Because in reality, it really depends on your relative power. So under a king, we're all protected. There'd be no distinction between migration status. There'd be no undocumented or documented. Everybody would be equal. But as I showed you in these three cases of the Rohingya, Louis, and Keshwar, they show that basically what ends up happening is that your social status, as it's determined by the nation state, and this really has only happened since 1945, uses laws to exclude people they don't want to include as quote-unquote the people. And this is not new to 1945, this is just what it's been happening since 1945. All democratic states, even going back to ancient Greece, have always been built on the idea of us versus them. The them are always slaves. And so this is in not just the public memory, it's not just in the experience, it's also in the legal language, right? So a very famous case, Scott versus Sanford, establishes this principle in the constitutional system that democracy, the group of people through their representatives, get to decide who the people are, which means they get to decide who to exclude. As you saw in that video about the lottery, it's the exact same system. It's just the lottery is a graphic novel kind of presentation of the concept. So this obviously leads to a paradox. On the one hand, we're entitled to human rights law, but there's no state government to enforce those rights. In other words, the state government, because it has the ability to exclude people who are not the people, then that means they don't have to apply rights to those people. And it's a very silly kind of contradiction, but it's a one that's very real and very much affects a large number of people, hundreds of millions of people. And then you see this idea of national rights are they're more important than individual rights, in other words, right? So your connection to the nation state, those rights that you get, those are more important than these individual human rights. And then finally, you need to understand that rights then are not held by individuals, they're held by social groups. So you only have individual rights if your social group is powerful enough in that society to provide those rights for you, to enforce them, to make sure that you get them. This is why mobilizing and protesting, these are signs that the group are trying to become stronger so that they can enforce rights. This then goes to the student essays, where they interviewed family and friends, and most of them were surprised by the diversity of experiences. They kind of tended to believe that everyone in their family would have the same view of what rights were, what power was, what law was, and how it affected social change. But what they found out is that their family members all saw it differently based on their lived experiences. And so we took this kind of common vocabulary and have really kind of unpacked it to see it's not what textbooks say. Sometimes you'll get somebody who says a very textbook-like answer, but then as they start to explain, they go very far away from that textbook answer. And so this is really interesting then to contrast to their own beliefs. They start to say, well, I guess I agree more with my dad, or I agree more with my mom or my sister, right? And they started then to be able to see that there are multiple narratives about what the law is, which we call legality narratives. This then gets you to see the analysis. You learn more about the tension between social control and rights. How what legal narrative you have will inform how you believe, what you think is important about social control, and what you believe about individual rights. Now, it'd be great if you could then pair that up with concepts of sovereignty and your social position, how you've been constituted in the structure. But I understand this is going to take some time. A lot of why it takes time is that you have to understand there are 4 dimensions of power. In other words, we have put together as social scientists that there's 4 ways that people tend to think about and use power in everyday life. So it's not just one thing. It certainly is a command, right? We understand this. You must comply or there's violent consequences. We call this domination. This really comes from the battlefield. This comes from war. But it's not just that, right? There's other ways of controlling. There's other ways of influencing people. And so power 2 is really a response to resistance, because in power 1, when you give a command, not everyone complies. And sometimes, I'll use a poker term here, they call the bluff. So sometimes the state or the individual or the corporation or the police officer or the military person, they all have the power, they have the ability to force you to comply. But sometimes they don't. And so when you resist and they don't have that power, they then have to respond. They have to come up with a new way. And so what tends to happen, we've noticed, is that that power holder then responds to the resistance by shifting towards the mobilization of bias, rulemaking, and also by granting certain rights and privileges as reform. This is a way of getting the resistor to stop resisting and to comply by giving them something that they want, but then also kicking them out or excluding them from the rulemaking process, so they have less power over the process, but they feel like they have more power because they have rights. Now this has led to a 3rd dimension of power, where those with exercising power begin to shape the needs and wants of the powerless so that they don't resist in the first place. In other words, that the powerless become so dependent on the powerful in their relationships that they aren't able to resist. And over time, this leads to something called hegemony, where the powerless know they're powerless and start to act against their own interests. In other words, they vote for people who aren't benefiting them at all. They're going to benefit a different group, but they think that they're getting benefited. They support causes that are actually against their self-interest. And so this all happens through the 3rd dimension of power. And then finally, there's the 4th dimension of power, which is exercised in the field of social relations. So if you look at this graphic over here, you'll see that these social groups, right? So I use 2 examples here. You've got the All Lives Matter group who want to fund cops more. They want to give them more money, much more money than they've been giving them in the past. And then you've got Black Lives Matter who want to defund the cops, who want to move money away from policing into other services like mental health services, gun background checks, pay for money, right? There's not just an unlimited amount of money, it has to be divided. And so they're saying because police have abused their power, they shouldn't be getting rewarded for that. But remember, police are in the power holder group, and so they're mobilized, they're biased. They get to participate in the rulemaking process along with the courts. So what you're seeing is criminal justice reform. Some rights are being granted, some punishments are being doled out, and this maintains an unequal relationship. Now the police are out to protect property, and so they don't really care about the catchphrase defund the cops. They don't really care about the catchphrase Black Lives Matter. What they care about is protest and the destruction of property. And so protests tend to lead to destruction of property. Now I'm not just talking about breaking windows and stealing things and looting. I'm talking about, even peaceful protests, right? They leave a mark. They interrupt business, right? They're interrupting the ordinary flow of property development. And so this has to be controlled. This is the social control versus the individual. And so you have this division here between protest and the rights of humans, right? On the other hand, that's an unequal power relationship. The police, the courts, and the powerful get to shape the needs and the wants so that even the protest has to occur at a certain time, a certain place, in a certain manner. The rights are very limited, right? They aren't unlimited rights, they're very limited by the power holders. This creates an issue where then you're likely to see violence on either side. Violence is a form of power 4 because it's going back to power 1, right? The law is a command, they're using violence, and so you have a violent response. And so you see this kind of full circle, and this is how it's exercised in the field of social relations and unequal power relationships. You can apply this in a number of situations, but I applied one that's been, more or less on people's minds. So if we go back to the concept of domination, right, it isn't the fact that it's a police officer, right? Sometimes we get confused about that. It's an exercise of power that requires compliance with the command because the consequences for disobedience include violence. So you see the stick kind of here in the police officer's hand. That's one instrument of violence. He also has the taser, he has the pepper spray, he has the gun, he has the car, right? He can ram you with this car. He can hit you with his hand. All of these instruments are what actually get people to command. It isn't the costume, right? The costume is the thing that we think gives him the authority to do such and such, right? That gets more to power 3. But power 1 here in domination are the instruments of violence. That's what's getting people to comply. It's the threat of violence. You have to then take this idea of, how power is being used and try to think about the criminal justice system and the legal system and what their goals are. It's a lovely motto when we say to protect and serve, but that's not really the goal. That's the motto, right? It's like you look at one of your favorite, beverages. They've got a motto. That's not their goal. Their goal is to sell as many beverages as possible. The motto, it really sometimes doesn't have anything to do with that. So again, protect and serve, it's a nice motto, but that's not the goal of the system. It's the same thing with establishing truth. Now that couldn't even happen, but it's also, it's a lovely motto, but it's not the goal. Same thing with provide justice for all. Again, very lovely motto, but not the goal. The goal is to close cases. And so how do we do this? Our inputs are the things that go into the system to close cases are stops, arrests, and charges. In other words, having the police officer stand threat of violence, stopping human beings, that's social control, and then filling out the appropriate paperwork to send them through the court system, those are the charges. What are the outputs of that system if it's successful, right? If it's successful and we're closing cases, then we should see outputs of prison, parole, and probation. The problem then is you see a loop, right? There's repeat offenders because the goal is not to rehabilitate. The goal is not to provide justice for all. The goal is not to protect and serve. It's to close cases. So you get this whole cycle again when the person gets out on parole or on probation, right? So unless they have changed or unless their social environment has changed or unless society has changed, right, the goal remains the same. Now you might want the goal to be rehabilitation. That might be a laudable or important goal for you. but that is not the goal of the system as it's designed right now. Then there's also two more dilemmas that a lot of you care about: wrongful conviction. What about the innocent people who get caught up in this case? Again, it's not about establishing the truth. It's not about finding who's innocent. It's about closing cases. So each part of the input system, right? The charges assume that the arrest was lawful. The arrest assumes that the stop was lawful. The stop assumes that the person is guilty, right? So they want to keep that system going to close the case. The last thing they want to hear is that there's been something wrong here. And so that's the other issue. What about errors in the process? What about, we're human beings. Human beings make mistakes. Well, the system doesn't want to reward that behavior. It wants to punish that behavior. And so a particular hard issue here then is we start learning about the quota system in policing. That's likely to produce errors, and it's likely to catch people up who are innocent. However, it's likely to close cases. And so the system says, yay, that's great. People who are caught up into it might not feel the same way. Same thing with stop and frisk. It's very efficient if you want to close cases. And same thing with the plea bargain. These things end the process, right? The system has its goal. Everybody can move on to the next thing. The problems within the system, the ones that require the reform, that's meaning that the system is not working efficiently. So this compared or contrasted to the concept of absolute freedom. In the Declaration of Independence, you have a natural right to freedom, absolute liberty. They make this as if it's obvious. They say this is obvious. Everyone is absolutely free. So the social contract is dependent upon freedom, right? So if my freedom is limited, I have the right to declare independence. A violation of freedom is what voids the social contract, making it legal or just for me to declare independence. And so in this system, freedom is the ultimate goal. That is not the same as the legal system in the criminal justice, where social control and closing cases are the goals. In the liberty or the freedom system, the system of everyone being free under the government, that's a very different goal, right? That's freedom. And so people who have power, people who have freedom, right, they see this as optional or advisable for all people who share freedom. It should be mandatory for the minority because they believe they haven't quite earned that freedom yet, that they haven't been recognized, and it should be guided by reason or choice, that your choice of freedom should be consistent with this theory of liberty. And so social control is unnecessary because all people are behaving more or less the same way, except for the minority. The minority has to be controlled and essentially taught how to be free. Now this is the theory, right? This is how people see this. So what you should have learned by this is that systems control behaviors, right? Depending, and this is obvious, right? Playing basketball, you're going to behave differently than if you're playing soccer, right? The rules are different, and so in any system, you're going to behave according to that system. So one super important finding that you'll probably read about quite often in criminal justice is the prisoner dilemma, the dilemma of prisoners. The first issue here is the lack of information, right? You don't know what your fellow accused prisoners are going to do or say. You also really don't know what the police officer or what the detective, the person that's coming to negotiate with you, you don't really know what he knows. And so in this kind of negotiation, there's a real problem of lack of information. Information will change how you behave dramatically. And so this is, a prisoner's dilemma is really a system in which there's very limited information. There's also this formula or a rule within this system of prisoner's dilemma. If there's a winner, then there's a loser. If a winner, then a loser. If a winner, then a loser. And so cooperation, working with the police, risks losing. You don't really benefit from that. You're going to lose something because you're admitting guilt. Now try to think in your mind, right? You have this Fifth Amendment individual right of not admitting guilt. You get to say, I'm not guilty, even if you're guilty of sin. You get to say you're not, and the police have to prove it. But again, you don't know what information they have, and so cooperation risks losing. Now, the best choice then is to cooperate only if you're guaranteed a win. So if you get information, which would be new information, right? The police or the lawyer or whoever is telling you, listen, we're going to let you be free, back to your system of freedom, if you cooperate with us and essentially rat on other people. And so you believe that ratting guarantees a win, or cooperation guarantees a win. But if the other rats too, then we both lose, and so we go back to cooperation risks losing. This is why it's called a dilemma. It's a paradox. I'm kind of hurt either way. If I don't participate and they have enough information to convict me, then I'm hurt. Or I'm hurt by participating and then the other person also rats on me, and so we both go to jail because they now have the information they didn't have. And that's really why it's a risk, is they didn't have the information. So this goes back to the unequal power relationships. And so there's lots of situations like this, right? We generally, in these relationships, the parent has more information than the child, and so they can organize or structure a win-lose situation there, where again, you either comply, you cooperate, or you resist. Teacher student, same deal. Police pedestrian, right? Person on the street, same situation. The lawyer or the judge and the accused, right? Same situation. They have unequal power, so they can structure these win-loss systems. So you have to start thinking about this unequal power relationship system as the status quo. This is how we go about our regular lives. This is how we've constructed society, giving power to these constituted identities of parent, teacher, police, judge, lawyer, right? There's others. Now it seems celebrities we could add to this list. So we see this then in empirical analysis. We provide statistics, we research it, we find out that it's a fact. Men get paid more than women. We have theories of deviance, right? Crime or deviant behavior is linked to things like sexuality or gender or preferences or religion. There's the legacy of anti-black slavery economics that continue to exist in redlining and other forms of gentrification. This same unequal power status quo exists among property owners and renters. That goes back to the Middle Ages. It's also rich creditors and middle-class debtors, right? So people who take advantage by charging usurious interest of people who need that money in order to have property. So property holders are taking advantage of their power to get people without property to borrow money so that they can get property, right? And so they're constantly in this unequal power relationship. So this shows us through this construct that society, we choose to participate in the system, that crime or deviance, behavior that goes against the power holders, that's what we socially construct as crime, right? Things that go against the status quo system. So then this should lead you to a concept of resistance, right? Resistance then is rooted in rights. They're saying that this unequal power relationship is not right. This isn't right. And so rights began in property. And so in other words, if I'm excluded from a particular property, the person excluding says, I own this property. This is my property. You're trespassing. But you can respond with the same logic. You can say, well, wait a second. Before you got here, this was shared property. This was common property. So we have a right to this property. Who gave you the right to own it? And so you see this logic now being born out of the same principle. And this then gives birth to this concept of rights. We all have rights, but there's also this tendency towards social control and the powerful trying to control the powerless. And so when the powerless resist this abuse of power, the dominator tries to make reforms to the system so the powerless stop the rebellion, but they only do that to continue their domination. It's kind of like a cat and mouse game. So then this is really where critical race theory comes in. So why is this important? Well, for a long time, hundreds of years, people, scholars, academics, professors, theorists, they operated under this idea that everyone had an equal chance, right? Because you're born into a certain social structure like capitalism, if you just work hard, then you'll get ahead. Well, in law schools, roughly in the 60s and 70s, people who were studying the civil rights movements, going back since the anti-slavery times, 200 years before, were arguing, well, this just isn't true, that some people are being routinely excluded, not because they're not trying hard, but because people in power positions are maintaining that unequal balance. In other words, it's designed to be unequal, and so even trying to be good or complying or working hard doesn't make any changes, and so they want to know, well, what can we do to actually make actual changes? So this pays attention to the legacy of an economic system based on anti-black racism. Slavery still exists today in lots of different parts of the world, including the United States, but it's different. It evolves, it changes, it attaches to different groups. But this particular anti-black racist-based slavery has had economic benefits to white people for hundreds of years, right? So they quote-unquote get ahead, right? They use that benefit at the expense and costs of African slaves to pass on wealth to their children, pass on education, knowledge, property, etc. Whereas people of color have not gotten that benefit, right? They put in the work, they had to bear all the costs. And so this is obvious, it's a social fact, it's an economic fact, but it wasn't being talked about. So were the ones who started talking about it because it really showed the limits of law, that law was not able to bring equality because of the economic system. And then we've learned more and more over the last 30 or 40 years that other groups are affected by this white-black tension, notably, right, undocumented populations, economic migrants, Muslim population after the World Trade Center attack, right? So there's been all these kind of different ways in which a white social structure benefits white people, wealthy and middle-class white people, but then, really at the expense and the cost of other groups of people. So then I'd like you to then think about privileged resistance, right? So the January 6th insurrection is a good example of this. I mean, if you really think clearly, their power was never restricted. They were able to walk onto the Capitol armed with weapons, no gun background checks, none of that stuff that people are arguing about now, and threaten Congress, right? Unthinkable, really, before that day. So then what exactly are they resisting? If there's no actual, right, there's no dominance, nobody's trying to control them, right? So they were resisting an idea, right? And the idea that they're resisting is they're based on their definition of sovereignty. Their idea of sovereignty is that the individual is the sovereign entitled to self-government. So they're declaring their independence against Congress. They're saying, you don't represent me, I'm going to remove you. And so this is not a rule for all, right? They're saying that other people have to comply with their rules. They don't think that they have to comply to the social contract rules. Remember, they don't believe in the social contract, they believe it's counsel, right? And so they are not dominated, they're among a group of dominators, and they don't want to negotiate with minorities, and so they are voiding the social contract. What they want is absolute freedom. They want to go back to a concept where they get to have absolute freedom. And this rests on the principle that law is advice. It's not required, it's not even morally obligated, it's a choice, because individual freedom and self-government is the higher value. So Dr. Martin Luther King Jr. called this difference made legal, where the mobilization of bias leads to the majority shaping rules, values, and norms, but then they don't apply those same laws to themselves. Now, one reason for this, as people like Dr. Derek Bell have identified, is that it's hard for white power holders to see non-whiteness, right? They don't know what it looks like. They don't live any other way. They only live in their own quote-unquote normal area. And so any behavior that's outside of that norm, then they constitute as criminal, as resistance, as something that's going against their belief system. And so this obviously creates a tension that's going to lead to further resistance, right? Not being recognized, not being given rights, people are going to start saying, well, this isn't fair, this isn't right. And so you've got this increase in tension, which explains a lot of where we are today. And so they continue their domination through rules, right? So the mobilization of bias, where you get to shape the rules, values, and norms. Great example from your American government class would have been looking at the Senate, right? Through the filibuster and how they get to block social change by just doing nothing, right? For just arguing and not actually having to address a single policy. And the way they do this is then by excluding others from participating. Get to participate in shaping of rules, values, and norms. So again, this is much more of the power three. They're shaping the needs and wants of people who are less powerful so that they become dependent on this system, which is a white cultural system. And so now this is, hopefully you're starting to understand the concept of white supremacy. It's not just people in hoods that chant in KKK rallies, it's a system. And it's a system that benefits white people and excludes and ignores people of color. So the last few slides, I just want to now get you to think about theory a little bit differently, right? A theory is, in this sense, right, legal theory, it's not about a philosophy, it's not about ancient history, it's about what do everyday people say and do. What do they think law is? What do they think legality is? What do you think it is? And then start to understand what are the different meanings of rights. How are people using these phrases differently? I've given you quite a few examples in this presentation. The next, you want to start to think about the cultural influence of meanings. So this text I have over here comes from Lynette Chua, who is doing some research in Southeast Asia. And so there's a lot of different cultures that exist in that region. And so there's this kind of argument that some people make about quote-unquote Asian values. And that applies to some cultural groups, but that doesn't apply to all cultural groups in Asia. And so she's looking at, well, how do these different cultural interpretations about values, about rights, about norms, about making rules, how does that change the way people behave and what their expectations are about rights? So this really starts to get you to think about a language environment. The way you talk about rights, the way you think about rights, the way you behave, the way you think law is going to work, that is really framed by the system around you, by your environment, by your language environment. So now we're talking about theory as a method of inquiry. We're getting started by asking the right questions. We're not going down the wrong road, we're starting with a good road. And so what we want to do here is we want to avoid overgeneralizations, which tend to be things you find in textbooks. We want to avoid myths, like the myth of rights, that rights are automatic and that you've got them, you possess them, and you're going to be able to use them whenever you want. And wrong-headed philosophies, like the separation of matter and mind, right? That's ridiculous. You can't have mind without matter, right? And so really trying to come up to date and really be accurate and very as rigorous as we possibly can about what's actually happening. Not what do we think might happen, not speculation, not thinking about what would be great if everything was perfect, but how do people actually behave here in the real world. So then I've given you this diagram of the legal system within the criminal justice. And so if we just start at the top, because that's going to be the easiest, you basically have the United States Supreme Court, the federal level, or the Court of Appeals in New York, where you have a panel of judges, right? You have a large number of judges, in this case 9, and they, it's not so much that they have power as much as they review lower courts. And so that's how they exercise their power, is through the review of lower courts. And so the lower court, the court below them, have different districts and circuits, as you're going to learn. So each region has their own set of 3 or more judges. That panel of judges, that's reviewed, that's checked by the higher court with 9 judges. But the 3-panel judge system also checks the lower system, which has 1 judge. So you go 1, 3, 9, right? You could even get more complicated that if you wanted to, but I'll let just the NCAA basketball fans, right? You can start thinking about all the different brackets that exist at the appeals court level. The point here is that the individual judge has the exercise of power of being the first, right? They get to make the first decision. But they're restricted by these 3 things: by the procedures of the court, by previous case rules, which we call precedent or stare decisis, and by professional standards of behavior that they learned in law school, that they learned by participating in the American Bar Association, and probably not been proven, but a lot of people speculate that judges also behave based on how they think people are going to receive them, what they think they're going to be thought about. So then within that system, you've got then an adversarial system. You've got the prosecution or the plaintiff, if it's a civil case, right, they're suing somebody, or prosecution if they're bringing a criminal charge. And then on the other side, you've got the defense, which, isn't that funny? It's defense either way, if it's civil or criminal. This is the person who's trying to stop this system, this case closing system, from coming after them. So the way that you see this, right, if you didn't have all these other bubbles, is you'd see, well, okay, this is one side, another side, referee in the middle. But that's not realistic, because you then have all these other pieces. You've got a system that has been designed, the mobilization of bias, of making the rules by wealthy white men. The next group that cooperates, complies, and benefits from that is middle-class folks with an education that good jobs, and they benefit from this system. These two groups tend to see law as with the law, it's a game, or before the law, that it's outside of them. And these tend to be the people who make up juries. Now, on the other hand, on the defense, you have people who are being targeted. And so these are African Americans who've experienced injustice, middle-class folks with an education who've experienced injustice, immigrants who experience injustice, women or non-binary people who have experienced injustice. There's probably more and more groups, right? Religious persecution. And so they don't tend to be a part of the design of the system. They've been pushed out of the system. Now, judges tend to be wealthy white men, so they are more likely to be biased towards that system and against a system that they don't know anything about. So the last part here, what I've tried to do is then just put all these terms out here to you, because you can start to see, what I'm hoping you can see, is that these terms then apply to scenarios or situations within this diagram. So precedent applies when a judge is deciding a case, and that makes the judge think about the appeals court. How is the appeals court? Are they going to overrule me if I get this precedent wrong, this rule that I'm supposed to understand from a previous case? Now, what makes that more complicated is that the defense and the prosecution are both arguing that the rule means different thing, that the precedent is on their side. Prosecution says this precedent shows that this person should be guilty. The defense says, no, this precedent shows that the person should be not guilty. So the judge has a very difficult job. So what most of them do is they defer to the appeals court. They don't make the decision. They say, well, let's let the appeals court decide. Okay, and then the appeals court tries to make the decision, but they also might get checked. They might get appealed by the highest court, by the highest court of either the state Court of Appeals in New York or of the federal system, the Supreme Court. And so this has this kind of effect. So the primary authority in this case are those cases. Is this case like a previous case? A secondary authority would be something like the Dahl studies in Brown versus Education. It could be research articles that professors like me and others write, or it could be some social science, research that they think is persuasive, or it could be a law from another country. Now, the elements of a crime and the burden of proof are things that the prosecution has to try to, develop over time and convince either the judge or jury. And so in the adversarial system of justice, then what you see is the defense is going to try to bring up a reasonable doubt, to try to say, no, you haven't met your burden of proof, or no, you haven't reached all the elements of the crime, you haven't proved it. Now, in a different system, say like the system in Italy, they have an inquisitorial system where all of the members participate in fact-finding. So it's not adversarial. It's a more cooperative structure, and it goes a lot slower, and it's got a different system for protecting rights. Then if we look over here on the upper right, we have to start thinking about different types of law. There's statutes, administrative regulations, and common law. The point here is that those can all be interpreted differently, and they are interpreted differently, because look at how many judges you have participating in reading these laws and trying to understand what they mean. So there isn't really like a final destination to decide, no, this is what this statute means. This then applies to what we mean by the judicial process. The process begins with this big mess of people that have unequal power. They have conflicts, whether they're suing each other or whether they're criminal behavior. They are then put into this factory in this process called the judicial system. And the judge, remember, what's their number one goal? You should be saying it out loud: to close cases. Now, the case is unresolved. It's not closed when it gets there. So the judge has this pressure to close the case. And so they're going to defer to the process. So the system has said that essentially, right, the stop was good, the arrest was good, the charge is good. So that means it's up to the defense to try to raise the argument that it's not. Now, this happens in both criminal law, which you probably know fairly well, and then also in civil law, which is actually the majority of lawsuits and part of the legal system. And this is, again, when people sue each other for violations of that social compact. You didn't hold up your end of the bargain. So then now you should start to see that the American criminal justice system is really, it's hard to really explain. Is it built around this system? Is it embedded in this system? Is it the mirror of this system? Is it outside this system, right? But what you should start to be thinking about is that they have a shared goal in closing cases, and so that's where they overlap. And so law enforcement is concerned with closing cases. Correctional agencies is concerned with keeping those cases closed. And so this is very much the crime control theory of criminal justice, right? This is about giving power to police officers so that they can quote unquote control crime. This is based out of military tactics and has been successful in military campaigns for thousands of years. Now, whether you should use military tactics in a civilian society, right, that's another question, but that leads you to the due process justice. It's much more focused on individual rights. So even if it might be effective to violate people's constitutional rights, should we have a society built on that? Now, these questions of either crime control or due process get worked out in the trial courts, going back all the way to the beginning to precedent, right? Judges will make decisions based on previous cases, they'll develop those cases, and it's scattered throughout this whole court system, whether it's the trial courts, the municipal courts at the lower level, like the MTA or the New York City. Then try to just keep in mind the appellate courts are always reviewing these decisions and correcting them, changing them, revising them, right? And then you've got a system where you've got district courts that could be very different from each other. So the district court down in Florida is very different than the courts in New York. So you kind of have this quote-unquote democracy side to the court system where you've got different ways of seeing these same laws. The circuit courts tend to be a little bit more uniform, but as the Ninth Circuit has kind of shown, they can be different in the way they handle cases. The Ninth Circuit likes to have a lot of judges that hear the appeals, whereas other courts don't have as many, and so these kind of processes change. Now, as you kind of go through these final concepts, then you've got a system of appeals, right, which is just really trying to, on one hand, close the case using as close of a precedent as possible. On the other hand, right, it's trying to establish future rules for future cases. And so this is really the job of the United States Supreme Court, is to try to establish some order out of this chaos of competing legal interpretations. Now, you probably know the defendant, the victim, the prosecutor, the defense attorney, right? Now, indigent defendants are those who can't pay for an attorney. That's the majority of people in criminal law, right? Cannot pay for their attorneys. So those criminal lawyers are very overworked. The trial judge is the one who sits over the trial, and they're the ones who make decisions on matters of law, right? Juries are the ones who decide facts. The bailiff, right, maintains order or tries to. The court clerk has a very important job, is the one who handles all the paperwork and makes sure everything is kind of running smoothly so that the case gets closed. The court reporter, probably not a job that will exist too much longer with voice recognition and computer software, but they of course keep track of the proceedings. Judicial administrators are interesting people. They are maintaining the whole system. They're trying to make sure judges have what they need, that the whole system is kind of functioning properly. And then obviously the chief judge or the presiding judge is usually the judge that's in charge of the panel, keeping the process going again. So what I've tried to do here is just to show you how the legal system is embedded in the society that we live in, and that the language really reflects different situations and different parts of the diagram. So then just to kind of close out here, right, you have to remember it's all about resolving open cases. That's what the courts are for. Right, so the goal of policing is to close cases. If they aren't closed, now we got to go to the courts. So this all began with suspicion, right? So was it reasonable or unreasonable? Well, who gets to decide that? So as you'll read, right, with Professor Chapman's article, the courts have basically said the police get to decide what's reasonable and what's not. An arrest begins when you are not free. So you have the natural declaration of independence to be free, but that ends the second that a police officer arrests you. You are no longer free, you are under social control. The plea bargain, right? Good advice, don't ever dance with the devil. As you see in the prisoner's dilemma, you're never going to win by cooperating, right? So, what the rational thing to do is to get a lawyer, and the lawyer will say, is my client being charged, and then on what evidence, and then the game begins, right? In the criminal proceedings, they'll have to produce evidence, and your lawyer will object to including it. They'll say, well, this shouldn't be included in the trial. In a civil case, it's very similar, but they bring what's called a motion to dismiss, right? So if a police abuses their power and they use excessive force against you, you might want to bring a civil case against them. They violated your constitutional rights. But the police, through the state, will bring a motion to dismiss. Their lawyers will say, we'd like to dismiss this case. And what they'll do is they'll want to argue that it was not excessive, that the force was not being excessive. And so the judge will make that decision. But, shouldn't the jury? That's what Professor Chapman's argument is implying, is that the jury should make these decisions. And it makes a big difference. Having 12 people who don't know much about law try to make findings of fact based on the story that they're hearing is very different than a judge that knows a lot about law but isn't really necessarily, listening to it the same way, right? They're thinking about being overturned, about the appeals process, about precedent, about the rules. They're not really thinking about the social dimension of the situation. And so then, just to remind you, judges read previous cases and identify rules to apply to, first, the evidence, so whether it should be included or not, jury decisions, whether their decision should be null, right? Should they overrule the jury decision? Jury instructions to how they should make their decision. The procedures of the court, which there's lots of procedures that I couldn't possibly get into in this class. The totality of the circumstance test, or the behavior of police officers, the elements of crime or civil law violation, and the severity of a sentence. So there's a lot that judges are really looking into the law to do during the whole process of a trial, or even before the trial, right? Most cases don't go to trial. They get closed very quickly through the plea bargain system. So the primary function of the courts in a criminal matter is to resolve cases that are still open from criminal investigation. So I know that that's a lot, right? But I wanted to try to just give you as much of the information in a clear, succinct way to just help you remember these concepts, and hopefully this helped as you're working through this class, that power is exercised, it's not held. I don't go to the store, buy a packet of power, and then use it. I don't throw my hands up in the air and say, I have the power, and a mighty sword appears in my hand. It's exercised through this field of social relations, and it's based on unequal social relationships. And so power is unequally distributed, and that's a choice that we all make in society based on our relative power. Your beliefs and my beliefs and education about what sovereignty is, it matters as to how we view the legal system and the criminal justice system. And it tends to differ based on our race, our class, and our gender and sexuality. Our different experiences lead to different expectations and language about what we think law is. Culture matters, and this influences our stories about legality, whether we believe that we are with the law, before the law, up against the law, or different things at different times. And just finally, theory is a method. It's an intro into learning more. So it's just a way of starting to really process and critically analyze new information.